Hi everybody, welcome to Employment Law This Week. I'm your host, George Whipple, an employment attorney at Epstein Becker Green. Every week, we'll bring you a rundown of the latest news in the field. We'll look at the latest trends, new developments that could impact your work, and important court decisions. Join us each Monday for a look at the news that matters to you, all in less than 5 minutes. Now let's get started. Our top story this week, a new standard for a new economy from the National Labor Relations Board. In its recent Browning-Ferris decision, the NLRB loosened the standard for determining who qualifies as a joint employer. The ruling expands joint employer status to businesses with the potential ability to control the terms and conditions of employment, whereas before it was limited to those who had exercised that ability. The ruling has been met with frustration on the part of employers, and a Senate panel was convened last week on the bill to roll it back. For now, though, the ruling is the law, and all employers should take note of the new standard. Attorney Stephen Swirsky has written extensively on this decision.
They are looking to say that whoever it is that actually controls the terms and conditions needs to be at the table if there are going to be negotiations. The big takeaways are if you are an employer and you're contracting for services, whether it's a call center, whether it's for the mailroom in your offices, whether it's to deliver your products or to take orders from your customers and someone else is doing it, there's a good likelihood now that, depending on the specific facts, the board would find that you are a joint employer of the personnel who perform those services that are a key part of your business.
Increased scrutiny on background checks across the country. We've seen a recent uptick in Fair Credit Reporting Act class action suits, focused on the notification process for background checks for new employees. Last week, a California federal judge dismissed a proposed class action accusing Kohl's department stores of violating the FCRA's clear and conspicuous and standalone provisions. Although that case was dismissed, it would be best for businesses to make sure consent forms for background checks are simple and straightforward. The Affordable Care Act's looming Cadillac Tax. How should you prepare? Despite a bipartisan push against the so-called Cadillac Tax, it remains set to go into effect in 2018. Businesses that have collectively bargained health care plans will most likely be hardest hit. Employers with unionized workers should take note when negotiating new contracts that extend into 2018. OSHA targets the healthcare and nursing care industries. The Occupational Safety and Health Administration recently increased its focus on both inpatient and outpatient facilities. OSHA fines have historically been very low, but the agency recently cited medical patient transportation company LifeFleet for several violations totaling more than $235,000. In order to avoid heavy fines, employers should consider conducting an internal OSHA compliance audit, reviewing your health and safety training programs, and consulting with an OSHA attorney to make sure you're prepared for an inspection. And that brings us to our in-house counsel tip of the week. This week, we have Rebecca White.
Get to know your colleagues in compliance and regulatory. Gone are the days when we handle employment cases in a vacuum. And if you're in a highly regulated industry like many of us are, particularly financial services, it's very rare that you'll find an employment case that doesn't have numerous regulatory and other ramifications. What you frequently see is that the employment case is the tail wagging a much more significant regulatory dog, and it will be a Pyrrhic victory if you end up getting a great resolution of your employment law matter that results in a regulatory fine or investigation. So don't let that happen. Get to know your colleagues, develop a rapport with them so that they come to you and you come to them. Enjoy what you do and be passionate, and you'll be great.
Thanks, Rebecca. Before we go, we want to invite you to come join us here on the show. Come share your in-house counsel tip of the week with our audience. Email us at thisweek@ebglaw.com if you're interested in being featured. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.